120 WPM English Shorthand Dictation. Be ready for it. Para. Start. Of the facts and circumstances of the case, there is sufficient reason for drawing adverse inference against the prosecution for not producing the parents of victim of the witness box before the trial court. Full stop. The evidence on record shows that PW1 and PW2 were not the eyewitnesses of alleged incident of fetching the victim by accused appellant in broad daylight at 10 a.m. instead of choosing some time of loneliness in the late evening or early morning, and they have been set up subsequently in order to improve the case against the accused persons. The above witnesses are interested witnesses, and their unnatural conduct of and contradictory testimony is not reliable for holding the accused appellant guilty, and the learned trial court has misread the evidence on record. Full stop. I am of the considered view that the prosecution has failed to prove its case to the hilt beyond any shadow of reasonable doubt, and has failed to bring home the charges against any of the accused by any cogent, reliable, independent, and trustworthy evidence. Full stop. Considering the totality of facts and circumstances, it is a fit case where the accused appellant is entitled to be given the benefit of doubt, and the prosecution case is liable to be rejected. The accused appellant is also entitled for an order of acquittal. Para. PW1 and PW2 are only chance witnesses and have also stated to have inquired into with co-accused as to where the victim and accused appellant have gone, but even when no reply was given by them, they did not inform the first informant or father of the victim, which is also quite unnatural, and their conduct is not doing so despite being related makes their contention of being eyewitnesses doubtful and untrustworthy. Similarly, on alleged asking by PW1 and PW2 from Rajendra and others not giving any threat by them is quite unnatural, while on mere inquiry by the first informant they allegedly threatened him. The first informant has not assigned any reason when neither he was eyewitness of the occurrence nor got any information from alleged eyewitnesses. Then why and on what ground he approached the family members of accused appellant, co-accused persons for inquiring about the victim. Para. Shri Raghavendra Kumar Singh, learned senior counsel for the respondent university, has invited the attention of the court to the entire material relating to parliamentary debates, the deliberations of the standing committee of the parliament, and the objects and reasons to contend that firstly, the university was established under a special act, namely the 1994 Act. The said act clearly provided for special reservation for scheduled castes, scheduled tribes, and accordingly informant the first academic ordinances provide for 50% reservation to such classes He therefore submits that this stood protected and could not be abrogated by the general provisions of the 2006 Act. His contention is that the 1994 Special Act continues to hold the field and any exercise of framing of ordinances under the said Act that provides for 50% reservation could not have been taken away, for which the amendment in the 2012 Act full stop